James Bresnahan's legal story starts in 1964. Could you?
It actually starts earlier than that.
It probably starts when he was born.
Yeah, almost. When he was about 9.
Tell us.
When he was born, that's right. Well,
in narrative form, who James Bresnahan was,
okay,
and who he is today.
James Bresnahan is a man who, when he was a boy at age 15, killed his mother and father, and he was convicted on pleas of guilty, being represented by a lawyer hired by his maternal grandfather, and he was sent to state prison at age 15. I'll get back to some of the details in a moment, but I was public defender, and I wasn't allowed to handle any other criminal cases. But what happened is that his father was a physician, and his father had quite a bit of life insurance. He had listed his wife as the beneficiary, the principal beneficiary, and as secondary beneficiaries his children, Jim being the oldest, and then a brother and a sister who were toddlers. The Prudential Insurance Company had this money, and they looked at the proceedings that had caused Jimmy to go to the state prison and felt that it wasn't an airtight case, and that if they were to under the law, if somebody kills an insured, they cannot recover the proceeds. So if he were guilty of murder, he would not receive this money. But if the conviction were set aside, he would have a legitimate claim to it. So the Prudential Insurance Company did what insurance companies frequently do in situations like that. They filed what's called an Interpleader Action, and they take the proceeds of the insurance, they deposit it in the court, and they advise the court that the following facts are: this father, the doctor died, was murdered, the mother was murdered, the oldest son at age 15 was convicted, and there are two other siblings, a son and a daughter, who are 1 and 2, very, very tiny. We don't know if the conviction set aside, we would end up having to pay twice, so we want the court to decide who gets the money. That's what an interpleader action is. Well, the judge in this court, Hatfield-Chilson, appointed a lawyer by the name of Ted Wood, who was the recently retired senior partner of an insurance law firm, Woodruss and Hames. And he knew him quite well, and Judge Chilson did. And he said, I have a matter I'd like you to take up as an officer of the court. And he said, there's no fee in it, there's an interpleader action, but I'd like you to be the guardian for this boy who's in prison and file a report. And he says it will take you undoubtedly a trip to Breckenridge, where the court records are, and to Canyon City to interview him, and then come back and file a report. And so Ted Wood said he would do it. And the first thing he did was go to Breckenridge, and the judge, state judge, wouldn't allow him to see the file. And because he said he didn't care what the federal court wanted. It was not, he wasn't an attorney in the case, and he couldn't see it. That judge didn't like lawyers from Denver under any circumstance, but at any rate, he went down to Canyon City to see the boy, and he wouldn't talk to him. So
this is James Bresnahan.
This is Jimmy Bresnahan. So he came back to Denver, and he reported to Judge Chilson that he couldn't do anything about this because the judge wouldn't let him and see the records, and the boy wouldn't talk to him. Well, at the same time that he was talking to Jimmy in jail, there was another prisoner there who I had represented as public defender, a guy by the name of, excuse me, a guy by the name of George Robert Gorski. And Gorski was a great character. I can tell you more about him later, but Gorski, I had been successful in getting his sentence cut from 16 years down to 8. So he thought that I was a miracle worker. And so he tells Jimmy, he says, well, you need to call John Kane. He says, write him a postcard. And Jimmy said, I don't want to talk to anybody. He says, this guy can help you. And he says, I'll even pay the dime for the stamp, for the postcard. So Ted Woods comes back down again to Canyon City to see Jimmy. And Jimmy says, the only person I'll talk to is John Kane. So Ted came back and he asked around if anybody knew who I was, etc. And some people knew about me being the public defender. And so he called and asked me to come down to the Denver Club, where I'd never been, for lunch. And I did, and he asked me if I would come in on the case. And I said, well, I can't. I'm public defender. I'm not allowed to have any criminal cases. He said, well, can you try? He said, I want you to represent me as the guardian. And so, you know, arguably it's not a criminal case. It's a habeas corpus, which technically is a civil case. So I said, well, I'll need to talk to the county commissioners. And I went back to Brighton and I asked for a meeting with them, and I did. And I told them what the situation was. And I was very surprised. They thought it was the greatest thing in the world. They were flattered that the Adams County was looking so good that a federal judge would want somebody from Adams County working on this case. So they said, by all means do. And so I agreed to represent Ted Wood, and we went down to Canyon City and I talked with Jimmy, and we started in an investigation. And as I say, Judge Luby wouldn't allow us to see anything. We finally were allowed to see the court files, and then we asked to see the probation report, and he wouldn't let us, so I initiated a mandamus proceeding in the Colorado Supreme Court and got an order that we could see it, and we did that. And then we went and filed a motion, and it was very difficult to do. The judge was very angry, and Ted was trying to argue it as the older person there, and Judge Luby at one point threatened him with sanctions, and he said, you're interfering with justice, and he kept saying, I'm not, I'm doing what Judge Chilson wants. Well, this isn't a federal court, you know. He got a lot of that kind of parochialism, but at any rate, we had to go back up to the Supreme Court again and get another mandamus, and then we tried to get a hearing, and he kept denying us a hearing. And he would do things like say, well, you didn't file a notice to set. We'd have to be in Denver, mail a notice to set to Breckenridge, and then drive up, at which point the clerk would then give us a hearing, and then we'd go before the judge on another date. It was just this effort to make everything as difficult as possible. Now, during this time, the district attorney up there, a man named Gene Lorick, was concerned enough that a 15-year-old boy is charged with murdering his parents, that he called the Colorado Psychiatric Hospital, and they sent 2 residents up to Breckenridge, or to Leadville, where the jail was, where he was being held, and they interviewed Jimmy before he had pled guilty. The 2 residents filed a report, and they said that they felt that an insanity plea was viable because of the battered child syndrome. And that sent the tenured faculty in charge of forensic psychiatry into orbit. The director of psychiatry there, John McDonald, was incensed that they would say this. And the reason is this. The examination was based on Jimmy being a battered child, which I'll go into in a moment. But the battered child syndrome was not at that point an accepted part of medical science. C. Henry Kemp had started the instruction and research on the battered child syndrome, and he had cooperated with a psychoanalyst at the faculty, and they had formulated the battered child syndrome. And basically what had happened is the pediatrician, Dr. Kemp, had looked at all these x-rays of injured children, and he would see old fracture lines. And that indicated, how can you have that many fractures? And so he continued his investigation and found that these children were battered. And then he got the psychoanalyst, Brant Steele was his name, to look at the psychoanalytic aspects of the battered child syndrome, and the two of them came out and formulated this. But it was being circulated at various medical conventions and so forth, and being published, the peer review literature. It had not yet been accepted as a valid doctrine in medicine. So the Department of Psychiatry at CU was very noticeably in disagreement over Freud. There was the psychoanalytic psychiatrists, and then there were the old classification type that did not believe in the Freudian approach. And the two of them fought all the time. Well, the director of forensic psychiatry, Dr. McDonald, was of the old school who rejected Freud. Brant Steele was of the Freudian school, in fact had known Freud. And so they fought all the time. Well, what McDonald did was call in these two residents and say, if you insist on pursuing this, he said, the Department of Psychiatry will disavow it, and I will recommend that your residencies be terminated. So we had evidence that we couldn't use. Evidence that in effect had been withdrawn and that was not part of an acceptable, recognized medical doctrine, to say, look, he was insane, he pled guilty, the insanity pleas have to, or the guilty pleas have to be set aside, and he has to be rearranged, and we can enter the insanity plea, etc. That was our strategy. So we reported back to Judge Chilson, and it was very interesting. Ted Wood said, well, he said, this is not insurance law. He said, and John's doing the job. I don't really need to be there anymore. And Chilson said, oh no, I want you there. I want you. And I said, I want John to continue to be representing you as the guardian ad litem. So till the day he died, Ted was working on that case with me. Now, at about this time, I was heading toward the Peace Corps, and so we didn't have a hearing yet in the Bresnahan case. And Don McDonald, who I mentioned earlier, was at CU, and he had gone into practice in Denver, and so I asked him to come in on the case, and he did. And then McDonald and I worked together, and then when I went to the Peace Corps, McDonald went to Ted Wood, and he said, I need help, and another lawyer, Dale Tooley, is going to run for district attorney, but he doesn't have any criminal law background, and he wants some, and he wants to come in on this case. And Ted Wood said, fine. So for the 2 years that I was gone, they were dealing with this case, and they had to make another trip to the Supreme Court. I can't recall what that one was about, but eventually they had the trial, and I came back, and when I came back from my Peace Corps tour, I contacted McDonald and Ted Wood, and they said, well, we had a hearing, but Judge Luby has never reached a verdict. And so
This is a hearing on whether or not
there was a full trial.
The guilty plea should be withdrawn, and
Right.
he should be allowed to plead insanity.
Right, and he had never ruled. the basis of it was that he was denied competent counsel because counsel should have seen to it that a 15-year-old with a battered child syndrome could plead not guilty by reason of insanity. And so this lawyer, who was from Cheyenne along with Jimmy's maternal father-in-law, had been hired by him, had come down. And my recollection is that this lawyer told Jimmy that if he wanted to, there was a possibility of his entering insanity pleas, but if he did, he would spend the rest of his life in an insane asylum, and plus the fact that even if he was found not guilty by reason of insanity, his grandparents would have to sell their house and lose all their money in order to pay for it. And so Jimmy said he didn't want any of that, and so he pled guilty. So there was some question of the methods used to extract a plea from him. At any rate, they had the hearing. Judge Luby never decided. So I said, well, mandamus again. We go up because there's a Colorado statute that says that if a judge has held a case under advisement for, I can't remember the time, but X number of months and doesn't decide it, you can, upon complaint, have his pay withheld.
It's 12 months.
Is it 12 months? Okay. Yeah. So anyway, I said, let's file that. So I prepared the mandamus proceedings, and I went to, it was in the state capitol building. This was before the judicial building was built. But I went over there, and I was walking in, and the state capitol had a coffee shop in the ground floor as you walked in without going up the big steps, sort of a basement. They had a coffee shop, and Chief Justice Pringle was there. So he said, oh, when did you get back? And I told him, a couple of months or something. And what are you doing now? And I told him, and I said, what do you got there? And I said, it's another Bresnahan mandamus petition. And he looks at me and he says, let me see it. And I handed it to him. And he said, he said, we don't need all this bad publicity. He said, let me call Luby. He said, can you withhold filing it for a week or so? And he says, I'll call him and tell him that he has to decide the case. So I said, sure. So I left, and Judge Pringle contacted Judge Luby, and then I think it was Pringle's assistant, Harry Lawson, who called me and said the chief has talked to Luby, and he gave him 30 days to come out with his decision, or he would impose the salary thing. So on the 29th day, Luby retired from office.
I never wrote.
Never wrote it. So they took the file, transcripts and everything, and they gave it to another judge. And the other judge was Dan Shannon, who was a good judge. He was in Jefferson County. But all he had was the record, and Luby wouldn't allow any information to come in. So the record was one that wasn't probative of the issues. And he said, I have to deny it on the basis of this record. But he said, I'm going to include in my opinion that I think that you should appeal this because the record is inadequate. So we said, okay. And so we filed a notice of appeal, and it went to the Colorado Supreme Court one more time, and they denied relief. And so we came over here to federal court. And this all had taken 10 years. So Jimmy was now no longer a 15-year-old kid, he was 25. And I'll tell you about his background and what he did later. But at any